All right, good afternoon, everyone. My name is Antonia. I'm going to be your moderator today. And before we kick it off and get straight to our speakers, I did want to take a moment to introduce them and just cover very briefly what we're going to go over in our session today. Our first speaker is Sarah Hanks. Sarah is the co-founder and CEO of CrowdCheck, which prepares diligence reports for crowdfunded offerings. But before founding CrowdCheck, Sarah actually worked at the SEC, and she had a hand in leading the team that actually drafted some of the regulations that we're going to be talking about today. And we also have David Lee with us. Dave is the founder and CEO of NetShares, which I feel like everyone here already knows Dave. He's been on a panel already so far, but if you want any more information about NetShares, I'm sure you can find Dave after the session. And Dave is great for this session because in addition to his role at NetShares, he's actually had experience on both the franchisor side and the franchisee side. So he really is the best of both worlds. And then we also have Warren Lewis. Warren is an attorney at Ackerman, and he co-chairs their franchise practice there. So welcome to Sarah, Warren, and Dave.
Thank you.
And before I turn it over to the speakers, just quickly, what we're going to cover today is just a little bit of background on the regulations themselves, some of the pros and cons of crowdfunding under both regulations CF and also A+. And then we're going to let our speakers share some of their insights about what type of companies this is really a good fit for, whether it's the franchisor side, the franchisee side, what we're looking for. We're also going to cover briefly some of the mechanics that go into an offer in terms of the time frame, what are the basic steps. And then we're going to end by transitioning into the franchise world, asking ourselves, how does the franchise regulation really overlap and in some cases can maybe conflict with the SEC regulations. And also we know some franchisees are going to be eager to try this for their own fundraising. And we wanted to talk a bit about if this is brought to a franchisor as an opportunity, what would the franchisor want to consider before approving its franchisee to raise funds this way? So that's the basic background. But we want to start with Sarah. So Sarah, could you just give us the basic elevator pitch for these regulations, CF and A+, and just tell us a little bit about what problem they were intended to solve?
Sure. And just I want to make one thing clear, that when I was at the SEC was a very long time ago, decades ago, and the rules that I wrote were some of the rules that influence these, but they aren't these rules. But with respect to the whole, the elevator pitch for Reg A, here's the guy who did, I think, the best job on summarizing them. This is President Obama way back in 2012 when he's signing the Jobs Act in the Rose Garden, and he says, right now, you can only turn to a limited group of investors, including banks and wealthy individuals, to get funding. Laws that are nearly 8 decades old made it impossible for others to invest. But a lot has changed in 80 years, and it's time our laws did as well. Because of this bill, startups and small businesses will now have access to a big new pool of potential investors, namely the American people. For the first time, ordinary Americans will be able to go online and invest in entrepreneurs that they believe in. And that's really the elevator pitch for the whole of all of the Jobs Act, especially Reg CF and Reg A, and also exactly what the previous panel was talking about in terms of who you reach out to. You reach out to your fans, your friends, your family, your fans. Up till the point where these new rules were adopted, most of the funding for early stage companies was from accredited investors, that is, rich folks, because all offerings of securities, and that's pretty much any kind of investment, have to be registered with the SEC, which is a very expensive and time-consuming process, or have to be made pursuant to an available exemption from that registration. And the only real formal exemption that was available for a very long time was Regulation D, a private placement to accredited investors, that is, rich folks, people who have incomes of $200,000 or net worth of $1 million. Some early stage companies made offerings to friends and family, and they would say sometimes, to us, their lawyers, we did a friends and family round. But because there was no real actual exemption from registration called a friends and family offering exemption, some of those offerings were made under very dubious circumstances. And that's where Reg CF and Reg A came in. They're new exemptions that say if you meet these terms, you do not have to register with the SEC. You can raise money from your friends, from your family, from your fans, from the people who eat your sandwiches, and you can do it over the internet, which was not previously allowed. And these days, of course, the technology that didn't exist even 20 years ago, never mind 80 years ago, makes it much easier for those offerings to be made. You can use technology like core connectors to reach out to massive numbers of investments in relatively small amounts. Like, some offerings are made in the amount of just $99, and you could buy a sandwich and just buy a couple of shares at the same time. Why not? So that's what all of this is about.
Thank you, Sarah. But we know it can't all be good news, so I did want to save more time for the bad news than the good. It is the legal session here, so we have to go over some of the hurdles. Sarah, do you mind walking us through some of those limitations and really some of the hurdles that somebody issuing under one of these regulations might expect to face?
Yeah, I mean, I wouldn't call them hurdles, but they are just things that you are going to have to comply with. So for Regulation CF, the rules are the offering has to be less than $5 million, can be equity, can be debt. You need reviewed or audited financial statements. And this is always the biggest and most expensive piece, more than the lawyers, more, than pretty much anything else. It's the thing that, many companies don't have audits. Now, it's great if you've got a franchise agreement that requires audited financials, make sure that those audits are produced in accordance with US GAAP, and you're good to go. But you do have to have, if you're raising up to $5 million, you need audited financials. If you're raising up to 1.07, which is a weird but inflation adjusted number, you need reviewed financial statements. The offerings have to go through an intermediary. That intermediary can be a funding portal, or it can be a broker dealer. One of the intermediaries is David, who's right here. But you do have to do the offering through the intermediary. And what the SEC is trying to do here is make sure that all of the information that an investor needs in order to make an informed investment decision is all in the same place. And everybody, the crowd, all treated equally, everybody's got access to the same information in the same place. The way you launch the offering is you file a Form C. Now that's going to consist of the boring bits that the lawyers make you do. It'll have risk factors, and this is how you go about doing the offering, and this is your rights under the offering, and this is the rights under whatever securities you're selling. And then it's also got the sexy stuff that you put online up front about this is why you want to invest in this particular franchisee or franchisor. All of that gets filed with the SEC. The SEC doesn't review it. People will only generally look at what is filed with the SEC when something goes wrong, which, cross fingers, it doesn't. But it's all there in one place on the SEC's site. You've got to comply with communications rules. The rules are unlimited with respect to where you can reach out. You can use TV, you can do skywriting, you can go online, you can do TikTok videos with a little dance and say, and now invest in my securities. However crazy, providing, number one, that you don't say anything that is untrue or misleading. And then secondly, the content is very, very constrained. So if you talk about the terms of the offering, that is, how much are you selling, what are you selling, what's the termination date, you can only produce that information very, very factual. Just when what the company is offering, and go to David's site to go and buy it. If you don't mention the terms, then you can be a bit more free-ranging, but then people are like, why are you going on TikTok and doing a dance about equity crowdfunding and you're not telling me what I'm selling? Well, that's why. The communications rules are complex and counterintuitive, but you've got to comply with them. And then with Reg CF, you have to do ongoing filing once a year, unaudited financials, telling everybody what you've done since. Regulation A is like the big brother or sister to Reg CF, and you'll notice I call it Reg A. That's its formal name. People call it Reg A plus because it's there was an original Reg A that nobody ever used, and when in 2015 the SEC changed the rules, everyone's like, that's A plus. So it's just a nickname. But anyway, under Reg A, you can raise up to $75 million a year. There are 2 tiers in Reg A. We ignore tier 1. You do not want to do a tier 1 offering. It's very, I'll explain at length, but it takes too long to explain why you're going to want to do a tier 2 offering. You need audited financials for 2 years. You file with the SEC. And this is a bit of the burden because the SEC reviews the offering and raises comments and says, give us more information about this and why is this not a risk, and please improve this disclosure. But you go through that process. And then when they are finished with their comments, they qualify the offering and you can start taking money. You don't have to go through a broker, but we very strongly recommend that you do. And then the communications rules that you have to comply with, completely different than Reg CF. So instead of monitoring, what you say, the Regulation A communications rules monitor the channel that you use. Pre-qualification with the SEC, you can use TV, you can use radio, you can use Wall Street Journal. Post-qualification with the SEC, you have to deliver an offering circular at the same time. So you can only really use online unless you are going physically in person delivering bits of paper, which is not what all of this is about. The ongoing filings requirements are semi-annual, unaudited and reviewed, annual audited financials, and you're going to have to keep that up until such time as you have less than 300 investors. And those are the burdens. And back to you. And any questions?
Thank you, Sarah. So I want to turn now for a moment back to Dave. So Dave, I think I have your file. So I'm going to pop it open. Dave is going to talk to us a little bit more just about how these types of offerings would work in practice. And so I want Dave to be able to share his experience on both the time frame and the steps that go into this. I am going to try to share my screen and we will see what happens. But Dave, if you want to get started, you're welcome to while this heats up.
Yeah, so typically, so a Reg A, the timeline for a Reg A, I was going to say Reg A plus, but I'll say Reg A, is going to be a lot different than a Reg CF. A Reg CF deal, I know we can typically get those up and running within a matter of 4 weeks or so. And I think when we're talking about a Reg CF offering for a franchisee, the first thing you want to do is to get franchisor approval, right? Because if you're a franchisor and you all of a sudden see one of your franchisees raising capital without your consent, you're like, whoa, what's going on here? And that's probably the last thing you want to see. And so getting franchisor approval is going to be very, very important. In fact, I think that's part of the franchise agreement. Before you sell a security in your company, you have to obtain approval for that. And of course, if you're a franchisor, this is an opportunity for you to hand select the franchisee that you want doing this for you, right? And so, as a franchisor, you obviously want to look at a franchisee who is successful, a franchisee who's complying with all the rules and is doing what the franchisor is asking them to do, is following the system, correctly and so forth. And so, the first step is to get that franchisor approval. And then the second step here in this process would be to then pick your funding portal or your intermediary, right? And currently, last I checked, there were about 75 or so funding portals. That number may have gone up. And there are about 3,400 or so broker dealers here in the US. And as I mentioned in the previous panel, not every broker dealer is doing, Reg CF deals. And so you want to, kind of find out who's doing, regulation crowdfunding and go with those. Of course, I'll raise my hand and say we are doing those. And, that's kind of self-promoting here. So once you pick your intermediary, immediately, or concurrent with that, you want to, start working with an attorney to put your business plan, your Form C in order, all your disclosures, your risks, and your offering circular together. And you want to find an attorney who's well versed in securities law. Sarah Hanks being obviously one of the top attorneys in the space, and her team at CrowdCheck can do a wonderful job there. And then as Sarah mentioned, finding a CPA that's going to do your financials for you, that would be the next step. And then we start working on your campaign page, putting your marketing materials together, your video, and your business plan on the campaign page, and make it compelling enough where, once a person visits that page, we can then convert that into actual investors. So you want to have a good, solid offering page put together. And then we go to market. We hire a marketing company. Typically, there are several marketing companies out there that specialize in equity crowdfunding. And so we have some, folks that we can refer you to. I know Sarah has quite a few that she's worked with in the past as well. And these people are there to help, drive traffic to your campaign page, to your offering page, and put your marketing automation together and your drip campaigns and so forth. That to me is probably the most important aspect in all of this, because you can have all your documents, your disclosures, your broker dealers, and everything in place, but if you're not driving traffic or marketing your deal, then all of that is really pointless, right? And so you really want to have a strong marketing strategy put together, and then you go to market, and hopefully you get funded. I've seen campaigns go live and get funded. I'd say a few months, or some campaigns don't get funded at all, and that's due to a variety of reasons. But and then after that, you close the deal, you start funds disbursements, and then the investor relations process begins. And as Massimo mentioned earlier in his presentation, that's going to be key to keeping your investors engaged. And once you start, your second, third, fourth, fifth round, you have, already an established relationship with your investor base. And so that investor relations is going to be very important. So that's pretty much kind of the timeline, I guess, based on the actual deal. The timelines are going to, differ, but generally speaking, this is probably what you can expect on a Reg CF campaign.
How about a Reg A, Dave? You said the Reg, what's the total timeline for a CF versus a Reg A?
So for a Reg A plus, and I haven't done one of these before, mind you, Sarah could probably speak to this better than I can, but my understanding is that a Reg A plus deal is going to take anywhere between 6 to 8 or 6 to 12 months.
It could be. I mean, if the company is like a normal company, that is, they are not, a crypto metaverse company, then we usually say if you leave 5 months, you should have a comfortable cushion, providing you are ready to go, providing the start point is the point where you already have financial statements. We've had companies get through in less than a month when we got a no review, which is something you sometimes get. And we've had one company that took 3 years because they're a crypto company. But 5 months is a good benchmark for a normal company.
And as far as the cost on a Reg A plus, Sarah, I mean, my understanding is that, on a Reg CF, we can probably, do it for under 10 when all is said and done. But for a Reg A plus, my understanding there is that, you can expect to incur costs anywhere between 80 to 100,000, which includes, legal fees, your audit, filing fees, et cetera.
That's right. I mean, just to give an indication of the relative amount of work that's involved. When we do our complete service, we have a complete diligence and disclosure and legal package for Reg CF. We charge $7,000, and that's everything you need. Same thing for Reg A, $60,000 is the starting point, and then if you're a REIT or you have selling shareholders, a little bit more. So that gives you a relative idea of the relative amount of work. But then on top of that, for Reg A, you've got state notice filing fees, which you don't have in Reg CF. And then, of course, you've got things like marketing. And of course, you can spend anything from $0 to, $1 trillion on marketing.
Yeah, so the thing I do want to say is that raising capital through equity crowdfunding, it's not cheap, right? You have to have capital to raise capital, and so not just on the upfront, getting everything set up, but also on the marketing costs as well. So please keep that in mind for the audience.
Great. So I want to piggyback off some things I heard Sarah and Dave just say. We wanted to talk a little bit about what type of company would be truly a good fit for crowdfunding or under Reg CF or A, I suppose. What would make them the right fit? I know, Sarah, there's going to be some legal qualifications. We could start there. But I do want to hear back from Dave about some of those companies that put themselves out there and they got nothing. And perhaps we could talk about what went wrong and what would make a company a better fit. But Sarah, why don't you start by telling us some legal qualifications before we hear some of the bad news from Dave?
Right. Yeah, and I'm glad you just sort of narrowed down what I'm going to say, because I am an absolute terrible predictor of who's going to succeed. I've had a couple of companies that I thought were brilliant companies. I would have invested in myself. Did nothing. But the legal requirements that make the things that make you eligible for doing a Reg CF or a Reg A offering is you've got to be a US company, or for Reg A you can also be Canadian, and you've got to be legit US company. You can't just be, somebody comes in from Estonia and goes, well, this is a good place to raise money, we'll just make a sister company or a sub company. If the money is going to be used for someone outside the US, it's not going to work. It can be an LLC or a C Corp. I mean, there are a lot of our companies still stay in the LLC format, even though eventually they're going to want to be C Corps. And then one thing that I wanted to flag is the common control issue. I said earlier that you can raise up to $5 million a year under Reg CF. That limit applies to the company and all of the other companies under common control with it. So if you have a franchisee who's got a number of different franchises that it is controlling, then you're probably going to run up against that $5 million limit. One thing in the very early days of Reg CF, when my colleagues and I looked at franchises, we thought, well, the franchisor is controlling, so that's not going to work. And it's only recently, I mean, when we first started talking to David, that we realized that we were completely wrong in our understanding of what control meant. But where you have somebody who, a company that has, say, 5 franchises, they're all going to be treated the same under the $5 million. And then it's just a question of, can you sell this investment? Don't look to me for that prediction, because I'm going to get it wrong. And will a funding portal accept you? So that would be something that we would go, hey, David's the expert here. He can tell you whether you're going to succeed.
Well, yeah, it's so raising capital through equity crowdfunding is a challenge, because you have to, drive traffic there. And if you don't have a good marketing strategy to drive traffic to that site, then it's going to be almost nearly impossible to get your deal funded. And so I think that's one of the biggest challenges that I'm seeing out there in the marketplace is, people getting or businesses getting these campaigns set up without much, resource, without a whole lot of resources being allocated towards marketing the deal. So that's kind of, where I see the challenges. But in terms of like who would qualify or who would this be best suited for, I would say, early stage or established companies that are looking to grow, add units, US-based companies, as Sarah mentioned, those would be perfect candidates. People that want to still maintain control over their companies, this would be probably a great solution. Another, way to look at this too is, if you want to, if you've been a franchisee or a franchisor and you've been operating your business for quite some time and you want to sort of monetize what you've worked, so hard for, and you want to sell a part of your franchise assets, this could be a good solution for you to sort of monetize and de-risk, your holdings in that franchise company. And this is a way for you to, sell a portion of it to the general public. This could be a great solution for that. If you want to maximize the value of the company, we mentioned earlier, valuations are typically, you'll get better valuations through a campaign like this, and most likely better than something like what a private equity firm would offer. So that this could be a good solution for that. And yeah, I think overall, it's also a good way to spread the risk out, right? Because if and I'm a franchisee too. I own some Cajun seafood franchises down here in Texas. And as I'm thinking about opening more units, and taking the capital that I have in my bank account to open more units, I start thinking about the risks that are involved, right? And especially today, you have COVID, you have other variants that are coming, you have war, you have inflation going through the roof, you have labor issues. I mean, it's a very challenging business environment, right? And so instead of taking all of my money out of my bank and, assuming 100% of the risk, why not spread it out and allow, your friends and family members to share in that risk, right? And from a franchisor perspective, I think, there's a lot of value to be gained from that, because at the end of the day, from, the franchisor, their interest is to have more units open. So I think from a risk management standpoint too, this could be a great solution.
We did get one question from the audience. I think it's probably for Dave. And the question was, do a lot of the brokers and these other intermediary portals that you're describing have their own network to market these offerings to, or is it strictly up to the issuer to do the hard work on finding the folks to sell this?
A little bit of both. So, most broker dealers or CF portals are going to have, an established investor base. But, a lot of times investors invest in these deals specifically for a particular deal, right? So they're not going on there to shop and see what other investment opportunities are out there. They may, but, more often than not, they're going to these sites to invest in one particular deal. So I think, most CF campaigns that have been successful hire a marketing firm to drive that traffic. And so, yeah, it'd probably be a combination of both the broker dealer and the funding portals, existing network of investors, plus, the marketing and the issuers, fan base, their customer base, their friends and family. I think, all of that combined is really what's going to help, get these deals funded.
Thank you, Dave. If anyone else has questions, feel free to throw them in the chat, and I'll try to sneak them in when we have breaks in the action. Otherwise, we can save a few for the end as well. But I'm going to transition now a bit more back to the legal side with Warren. Warren, you're going to be our franchise law guru for the afternoon. So we understand that obviously the SEC has a lot of regulations around these types of offerings, but franchising is known for being highly regulated as well. And a lot of the same types of regulations about disclosure and advertising and what you can do and what you can say. Can you talk to us just a bit about the overlap between these two areas? These regulatory schemes complement each other overall?
Thank you, Antonia. I think I invite you to be a co-franchising guru on here because you're also a franchising lawyer. And you and I are coming at this from a different angle than David and Sarah. I see two questions as a franchise. I'm with a law firm, Ackerman LLP. I represent franchisors. We have we represent about 100 brands. So this whole idea of raising capital through crowdfunding is very intriguing and exciting. Two questions I see initially. If a client comes to me and says, I'm thinking about crowdfunding, should they even consider it? And then what is the interplay between the SEC requirements and the FTC requirements? So in terms of the first issue, should the franchisor even consider it? One of the objections I've heard from a lot of people that I've discussed this with is, oh, franchisors haven't used it. There are a lot of reasons for that I've learned over the past several months. And that is that it's fairly new in terms of the new limits that are permitted. The old CF limit was $1,070,000. Not that attractive. Now it's $5 million. That's far more attractive, particularly for a franchisor who's maybe just trying to create a better infrastructure for franchising, better technology, et cetera. And then you have the higher limit on the Reg A, which up to 75 million, it would be a great way to raise money to build restaurants or other facilities. So also the whole purpose of these two regulations is to permit small and medium-sized businesses to raise capital. Well, guess what? Many franchisors are small to medium-sized businesses. But I think they have an advantage over many other small to medium-sized businesses, and that is because franchising has a lot more sizzle, I think, than most other businesses. And also perhaps operating a restaurant, a themed restaurant has more sizzle than operating some other types of businesses. So you have perhaps more built-in interest in the concept. Also, if you have a franchise system with multiple franchisees, you have a system that's proven itself. So you have something to sell. It's not just an idea. You've gone beyond just a concept. And also, franchise units tend to have good relationships with customers. They have a feel-good relationship. They have a look and feel that people can understand. They're easy to understand. So I think there are a lot of advantages. There are disadvantages, obviously. It's not well understood, so you really do have to educate yourself. You do have the SEC obligations that you have to consider. There are compliance, fraud issues, but you have those issues already in the franchise industry, and that's why the FTC regulates franchising and the SEC is regulating this area. So from a franchisor standpoint, you're already regulated by the Federal Trade Commission. You have disclosure requirements, and you have advertising restrictions. The same would be true for under the crowdfunding. The SEC has disclosure requirements and advertising restrictions. Now they're different, but they're also overlapping. And so you can't just if you're a franchisor, you have a franchise disclosure document, and that's the content is established by the FTC and by the states. You can take a lot of that information and use it in the SEC offering statement. For example, franchisors, if they've been in business for a few years, have to have audits. So you have audits. That's a big a barrier that you don't have if you're going from franchising into an offering, a crowdfunding offering. You have many of the pieces of information in the disclosure document for franchising would overlap with the SEC offering statement, the company background, the financials, description of the business, the background of the people involved. So you have all that information ready. There are a lot of differences, so that you'll have to disclose a lot more information that you would consider perhaps confidential or internal as a franchisor. Ownership interests. When you're a franchisor, you don't disclose all the who owns what and what the voting rights are and that type of thing as a general rule. So you would have to disclose that. You would have different advertising restrictions. You would not, in some of the SEC statements, you have to give compensation of your officers and directors. None of that in franchising. The risk factors, there are risk factors in franchising, but they're very different from the types of risk factors that you see in an SEC type document. And then use the proceeds. You have to explain how you're going to use the proceeds. Another issue from a franchisor standpoint is that franchisors are very restricted in terms of the types of financial performance representations they can make. They very rarely make projections because that's too dangerous for them. Whereas in these SEC statements, there are projections and there are performance and there are projected profits. That's not something that you're going to have in a franchise disclosure document.
Actually, Warren, I would jump in there because, and anybody who works with us, we really strongly advise not having projections. It's the single thing that's most likely to get you sued. But because of what I said earlier about, the SEC doesn't review these. If the SEC reviewed them, they'd be saying, well, you need really robust assumptions behind these. And it's not just, God willing and the creek don't rise. It's like we have to sell this amount of stuff and be open this number of days. And, they really do have to be robust. So when we're involved, we really discourage the projections. I'm sure that'll make you happy.
Well, no, it does, because you're going to have, if you're going to be making, well, from the franchisor standpoint, if you're going to be making an offering, you're going to have your franchise disclosure document right beside the offering statement. Well, they had better not contradict each other. That's a built-in lawsuit if you're saying one thing in one and something in another. So you need to be very careful about.
Yeah, I'll jump in here too and say that on the franchising side, Sarah, I similarly often recommend clients don't try to add projections. I know you can, but I think it's always safer to rely on historical performance numbers that are actually validated as having occurred in that way versus trying to guess what a unit might experience in the future. Also a heavily litigated area in the franchise world.
I'll bet. Yes.
Now, in terms of, we've also looked at, that's from the franchisor side. When you have the brand protection issue, I mean, the franchisor has spent presumably all of its efforts to build the brand. So you want to protect the brand. So if the franchisor is doing the crowdfunding, they'll do it in a way that protects the brand, or otherwise they're not being responsible to themselves. When you're talking about having an area developer or a multi-unit operator of the franchisor doing the crowdfunding, there I think you really need to have controls, very tight controls, to make sure that you're protecting the brand, because the brand is owned by the franchisor, not by the issuer of the.
I have another question from the audience before we move away from projections, and the question was, if you don't provide them, does that impede your ability to raise? I know this is a common question on the franchise side as well, where we have folks selling with no representations of any kind. And we say, well, if your brand is hot enough and people really want it, maybe you can get away with it, but it's harder. Sarah, what's your experience been in terms of offerings where there's no projections?
Yeah, I mean, we don't let our issuers use projections. We know a number of platforms who will not let them use either, for exactly the same reasons, because the platforms are responsible too. I mean, yeah, you could definitely say if you had projections, you would sell more, sure, and then you'll get sued when you fail to reach those. And wouldn't you rather like not get sued in the end? So I mean, that sounds a bit specious, but seriously, it is the thing. Traditionally, through all of securities law, it is the thing most likely to get you into litigation, is to have a hockey stick and then fail to comply with the hockey stick.
Right.
And whereas, in Regulation D offerings, when you're selling to angels and venture capitalists, they're like, yeah, we knew that was not true. We're professionals. When you're selling to retail investors, the public, yeah, they didn't.
Okay, well, I do want to transition a little bit more into the one more topic. I know we're getting a little closer on time. So one of the areas that I've already gotten 2 questions from the audience on this as well is if we transition to the world of, let's assume the franchisee wants to be the one doing the offering and you're the franchisor, how do you look at that? What do you consider about whether or not to approve it? And do you consider having certain standard criteria that people have to meet if they want to get approved for this type of capital raise?
Well, it's been stated in the earlier panels, this is a whole new area. And particularly since May, it really was March of last year, March of 2021, when the limits were increased. So you're really talking just not even a year that these higher limits have been in place. So I have not found any franchise agreement, including my own, that addresses anything like crowdfunding. There may be some out there. Most franchise agreements don't even address the issue of a public offering. When these franchise agreements were developed over the past 75 years, and people, lawyers that create the agreements, you try to keep up, you try to keep the franchise agreements up to date. This stuff has not been addressed. For the most part, franchise agreements are silent on any type of public offering. Some of them prohibit a public offering. So if they prohibit a public offering by the franchisee, then the franchisor would have the most leverage, because they could say, if a franchisee comes to them and says, I want to do one, the franchisor would say, it's prohibited. However, since you're such a good person, I will let you try it subject to the following 20 conditions. You would have the leverage to do that. But in many agreements, it's not prohibited. And so the question then is, how do you then cobble together as the franchisor the right to put conditions on crowdfunding by a franchisee? And when I say cobble together, I mean, you want to have tight controls. You probably have the right to consent or not to consent, probably based on standard language. You do have the right to do that. However, when you get into the actual language of the contract, in most cases, it assumes that the franchisee is selling the entire company to somebody new. They're transferring it to a family member. They're converting it over to an entity from a personal ownership, or they've died or become disabled. I mean, those are the assumptions. It doesn't take into account selling a small amount of shares in the company to the public. So you do for the most part, all of the various conditions to transfer that contained in a standard agreement don't apply. Training, you're not going to require these crowdfunding people be trained to sign personal guarantees, to sign new franchise agreements. It's inapplicable. So so that's a given. However, you can withhold consent reasonably. You can't withhold it unreasonably. So then the question is, what can you say to the franchisee if a public offering is not prohibited? What can you say about the conditions? Any conditions you would put on it, you would have to say, come within the language. I can withhold this, or if I impose reasonable conditions. So in terms of some of the reasonable conditions, use of approved intermediaries or reviewed, consented to intermediaries. So you make sure they're getting the right people, the right lawyers, the right broker dealers. Approval of the text, of the video, of the photos that are used. Use of the trademark. Approval of the rights you could say, look, I even want to approve the rights being offered to the investors. Now, there's a question there whether that's reasonable or not. I think that could be litigated. One of the big issues in this area is that transfer fees tend to be very low in a franchise agreement. It tends to be maybe $5,000 or $10,000. That's not enough to cover the cost for a franchisor to review a crowdfunding offer. But I don't see any way. I think that it would be unreasonable, probably, to say to the franchisee, well, I'm going to double or triple or multiply that fee times 10 in your case. So that could be a potential area of dispute with the franchisee. You also have the control of the trademark, so you can rely on that. Control of the suppliers, the confidentiality, indemnification. There are a lot of pieces of the franchise agreement that you can use to say you have the right to regulate crowdfunding offers.
Right.
So I think I think that franchisors need to consider revising their franchise agreements to address this. If they want to permit it or encourage it, they ought to amend their franchise agreements to address what types of conditions that will apply. And also they need to develop their own internal checklists. And if those checklists could change, that could be part of their operating manual. They could say that crowdfunding has to comply with various conditions, plus any others that are included in the manual, for example.
So I will say we only have 10 minutes left. So if there are questions, I do hope you add them to the panel. Otherwise, we're just going to keep rolling. So now's your chance to ask questions. Yeah, to follow up on the things Warren was saying, it's difficult in my mind to imagine a scenario where the franchisor doesn't have to be involved in the process just due to the use of the marks and et cetera. But if you were a franchisee and you were going to your franchisor for approval, I know one of the first things I might mention to them is, look, this is better than a bank. At least you won't be second in priority, because if, the number of times where a franchise location has bank debt and something goes wrong or there's a closure, well, the franchisor never, is often so far down the thread after all the banks come in that there's nothing left, So a lot of the franchisors' privileges might be improved without that layer of secured debt in the middle. But Dave, do you have any experience about what has happened when a franchisee goes to the franchisor on a system and says, I know no one's done this in your system before, but here's some things you should consider about why this is now a good idea for you to think about approving?
Yeah, there's not a lot of use cases or case studies in this. I mean, there are a few, like I know Ben and Jerry's did a deal a while back for a Venice Beach location, but in terms of the benefits, I guess the main benefit to the franchisor would be more units open, right? And so it shouldn't take much to get the franchisor on board with this. I think for me, if you're looking at this from a franchisor perspective, the biggest concern for me would be if I as a franchisor would be subject to liability if the franchisee violates securities law, right? And so, what happens in that case? So that would be probably a concern.
Sarah, do you have any thoughts on that topic? How would that work? If there was somebody saying things that were inaccurate about the brand, but it was the franchisee that was making the offering?
Yeah, I think you'd have to look at it to see whether that there's some form of agency relationship there. You know, whether one could be deemed to be the agent for the other, and I think one of the things that you're really going to have to focus on in this area is the circumstances in which somebody can be saying something that you have either linked to or incorporated by reference, and it turns out to be wrong. I mean, for example, what if the franchisor were to have like a standard package of, you know, this is the sort of thing that you, information that you want people to focus on, and you link to it and it turns out to be wrong. If you incorporate it, link to it, you've adopted it. That's the problem.
So that also ties back to some of the points that Warren was making about when the franchisor is considering how heavily to be involved and what to really require of its franchisee. Warren, do you see a scenario in which the franchisor might be better off saying, you know, let me approve the way you use the logos, and maybe let me put my eyes on it for a final thing, but otherwise I don't want anything to do with it. Or is there, talk to me about finding that balance?
I would tend to go into, I want to see it. I want to very carefully, I would advise the franchisor to very carefully review it. I don't think, if the minute you look at it and you spend 10 minutes on it, the assumption would be, I mean, you linked to it, you looked at it. If there's something false there, you should have said something. I think you're going to be held to that if you touch it. So you might as well touch it properly. There was a question too about, wouldn't the standard shift in majority ownership clause cover this type of a transfer? No, a crowdfund, one of the great benefits of crowdfunding is you're going to give them a small part of your company, a non-voting shares. It could be common shares, it could be B shares, it could be convertible shares. I'm not an expert in securities, but it could be any kind of shares, but they're going to be non-voting. They're not going to be controlling. So many franchise agreements don't even address not the transfer of non-controlling. They may only say you have to give us notice of a transfer. Just let us know that you made a transfer, and they wouldn't even control it. So in that case, the franchise is going to have to use their trademarks and their other the language in the franchise agreements to try to control. I just don't, I think you want to, I mean, I think the point that was made earlier for the Reg A, we can raise up to 75 million. That's perfect for a multi-unit developer. But you don't want them out raising $75 million when you don't control what they're saying to people about your brand. I just think could be very difficult. Put you in a bad situation.
That's the age-old question on franchising, right? How much control to exert to protect your brand versus being held liable for what you're asking people to do. Okay, we only have about a little under 5 minutes here. I just wanted to, we'll go one at a time. Because of the order on my screen, I'm going to go Dave, Sarah, Warren. And just your last 2 cents that you want the audience to know, tips about the process, just that one little nugget that if they could take nothing else away, you want them to take home with them today. Dave, let's start with you.
Yeah, so I would just advise people to get educated here on what you can do with these new rules with the Jobs Act. The opportunities are limitless in terms of the type of growth you can see. I would just emphasize the importance of marketing because again, like we could have these campaigns set up, but if you're not driving traffic, if you're not getting eyeballs to the page, then it's not going to work. And so emphasis on marketing is probably what I would stress.
All right, Sarah, your turn.
Well, I totally agree with the marketing. I mean, however good or attractive the offering is, if people don't know it's there, then it's not going to succeed. But bear in mind that you can use a lot of different channels for marketing, including print out a link to David's website on your napkins as you hand them out. That's legal, crazy as it seems. The thing I would emphasize is ongoing reporting. There are going to be ongoing reporting requirements. Reg CF, compliance with ongoing reporting is terrible. And that's going to bring disrepute to the whole industry. So only do this when you know what your ongoing obligations are, and then comply with them.
All right, Warren, your turn.
Don't discount crowdfunding because you don't know that much about it. Most franchise lawyers, I've talked to many franchise lawyers about this, franchisers, they know nothing about crowdfunding, and they have negative feelings about it. Fraud, non-compliance. Oh no, that's just to fund projects like charities. There are a lot of misunderstandings about crowdfunding. It's really a way to raise capital, and it's made for small to medium-sized businesses, which is a perfect fit. And you've got an advantage over you already know how to comply with the FTC regulations, which in many cases don't make any sense. They go against common sense. And I'm sure a lot about the SEC rules go against common sense also. So you're already used to dealing with,
Sarah.
you're used to dealing with regulations that really don't make a lot of sense to you, but you have to comply anyway. So it's just another group of regulations that you'll have to comply with.
Well, I want to thank all of our speakers. This has been, I hope, a very educational session for everyone involved. There is a break for this session, so please go back to the lounge so that you could chat with other participants. And if anyone has any questions for our speakers offline, I think all of our information is in there and available for anybody. So it was nice to see everyone, and hope to see everyone soon.
Thank you.
Thanks, Antonia.
Thanks.